Welcome back to the Deep Dive, your go-to guide for cutting through the noise and getting straight to the core of complex topics. We take your sources, your notes, your questions, and we transform them into a personalized knowledge shortcut. Today, we're taking a deep dive into something incredibly practical and specifically tailored for you, the California legal aspects of real estate. You recently shared some insights from your practice test, pinpointing a few concepts that proved a bit slippery. So we're not just doing a general overview today. Think of this as your personal audio study session, really designed to tackle those specific areas where, the nuances might have been a little fuzzy. Our mission is to solidify those aha moments and turn those tricky spots into absolute clarity. We're calling this session Decoding Your Exam Traps because, let's be honest, these exams love to hide crucial nuances in plain sight.
That's precisely right. Our mission today is really to transform those challenging questions into crystal clear, actionable knowledge. We'll revisit key definitions, connect the dots between related concepts in ways that makes them stick, and importantly, explore the why behind the rules. So you don't just memorize an answer, but truly understand the principles at play. We'll be pulling directly from your study guide and practice questions to make sure we cover all the necessary ground, focusing specifically on what you found challenging.
So if you're ready to tackle those specific hurdles head on and make sure they don't trip you up again, grab your favorite beverage, maybe a notebook to jot down those insights, and let's unpack this. Hashtag, ARA. Untangling agency relationships and their endings. First up, let's dive into the fascinating world of agency relationships, specifically how they end. Your practice test highlighted a common point of confusion: the difference between agency terminations due to external events versus those that come from deliberate actions. It's like the difference between, I don't know, a natural disaster ending a contract versus someone just deciding to fire their agent. So what's the fundamental distinction here, and why does it matter so much?
That's an excellent place to start because it really gets to the heart of contractual obligations and, frankly, where liability might lie. What's crucial here is understanding the distinction between two primary umbrella classifications for agency termination: operation of law and acts of the parties. These aren't just academic terms. They have very real, practical implications for how an agency relationship concludes and whether any party might face consequences or, incur liability. Let's first talk about operation of law. This category refers to circumstances or changes affecting the contract that result in automatic agency termination, completely without regard to the desires or intent of the parties involved. Think of it like a legal force majeure event or simply the universe stepping in. The agreement automatically ends because the fundamental conditions that allowed it to exist have been, irrevocably changed. One of the clearest examples, and one that appeared in your practice test, is the destruction of property. If the subject of the agency, say a home that was listed for sale, is significantly destroyed, perhaps it washes away in a flood or burns down in a fire, the agreement can no longer be fulfilled. How can an agent sell something that no longer exists in its original habitable form? The contract is terminated by law because its very object is gone.
Right, that makes intuitive sense. You can't sell what's not there.
Exactly. And beyond property destruction, other specific triggers for termination by operation of law include the death or incapacity of either the principal or the agent. If one of the key parties becomes legally unable to perform their part of the agreement due to death or incapacitation, the agency generally terminates automatically. Imagine a seller who lists their home and then passes away before the sale closes. Well, the agent no longer has a living principal to act on behalf of, and the agency legally ceases.
Okay.
Similarly, if the agent becomes legally incapacitated, they can't fulfill their fiduciary duties. Bankruptcy of either party can also lead to termination by operation of law because it legally alters the financial and contractual standing of the individual or entity. Their ability to fulfill the contract might be fundamentally compromised.
Okay. That's another automatic one.
Yes, and crucially, a point that often trips people up. If a sponsoring broker loses their license, all agency relationships under that broker are terminated by operation of law. This means any associate licensee working under that broker suddenly finds themselves without a valid agency to operate under. They would immediately need to find a new sponsoring broker and form a new agency agreement to continue working with a client. It's like an automatic reset button for their agency ties.
Wow. Okay, so that impacts everyone under that broker.
Instantly. Finally, condemnation, which is the legal seizure of property by the government through eminent domain for public use, also terminates agency by operation of law. Once the government takes possession, any existing agency relationships based on private efforts to sell the property become void, as the property is no longer available for private sale. So the insightful takeaway here is this: these operation of law terminations occur irrespective of anyone's wishes. They highlight the powerful, often unavoidable impact of external legal frameworks or unforeseen events on contractual agreements. There's usually no blame or liability for non-performance because the circumstances are beyond control.
Got it. So acts of God or legal necessities, basically.
Pretty much. Now let's contrast that with acts of the parties. This classification covers any action taken by one or more of the parties that directly results in the termination of the agreement. It's about intent and initiation, a deliberate choice or action by a human being, not an external legal force.
Okay, so this is where people make choices.
Exactly. The most positive way for an agency to terminate is through performance, where both parties simply fulfill all their obligations as outlined in the agreement. The house sells, the buyer buys, the agent gets paid, and everyone walks away happy, the contract having run its full course.
The ideal scenario.
Absolutely. Another common way is by mutual agreement, also known as rescission. This is when both parties agree to end the agreement early and essentially put themselves back in a position as though the contract never existed. Perhaps the seller decided not to move or the buyer's financial situation changed. It's crucial that this agreement to terminate is always put in writing, just like the original contract, to avoid future disputes.
Good point. Always get it in writing.
Always. Then you have instances where one party decides to end the relationship unilaterally. Revocation is when the principal, or the client, terminates the agent's authority. Your practice test example of Peter not trusting his broker anymore and firing them, that's a perfect illustration of revocation.
Ah, okay. The client firing the agent.
Right. While the client can certainly do this, depending on the terms of the agreement, they might face liability for breach of contract, especially if the agent was performing their duties effectively and the principal terminated without cause. Conversely, renunciation is when the agent renounces their authority and willingness to act on the principal's behalf.
So the agent firing the client, in effect.
Essentially, yes. An agent might do this if the client is asking them to perform illegal or unethical actions, or if the relationship has simply become unworkable. Lastly, a breach occurs when a party fails to perform according to the contract terms without cause. When a party breaches, it terminates the defaulting party's rights under the contract while generally maintaining their obligations. So if an agent breaches the contract, they might lose their right to a commission, but still be liable for damages to the client.
Okay, so that carries consequences.
Definitely. The key takeaway here and the core insight is that acts of the parties, terminations, are driven by the will or actions of the people involved. This means they often come with specific consequences and potential liabilities outlined in the contract, unlike the automatic, no-fault nature of operation of law terminations. It's the difference between a natural disaster ending a deal and a handshake deal falling apart because someone changed their mind or didn't follow through.
That distinction between operation of law and acts of the parties is crucial and makes so much more sense when you frame it as unavoidable versus deliberate. But what about the finer points of authority? For example, I've heard some agents can sign on behalf of their clients while others can't. Is that true? And if so, how do we distinguish which ones have that power to bind the principal? Our listener found that a bit tricky in the test.
That's a crucial point you're highlighting, because not all agency relationships grant the agent the same level of authority to bind the principal. The ability to bind means the agent can legally commit their client to a contract or agreement without the client's direct signature or explicit approval for each specific action. We categorize agency by the scope of authority granted, and your test specifically asked which two classifications come with this authority to bind. Let's break down all three main types.
Okay, let's do it.
First, we have special agency. This is the most limited form, and it's typically what you see between a real estate broker and their client, whether that's a buyer or a seller. In a special agency relationship, the agent is authorized only to perform very specific, defined acts permitted by the principal. They do not have the authority to bind the principal to contracts.
So a listing agent can't just sign the purchase agreement for the seller.
Exactly. A listing agent can find a buyer, negotiate terms, present offers, but they cannot sign that purchase agreement on behalf of the seller. The seller ultimately has to review and sign the contract themselves. Similarly, a buyer's agent can't sign an offer on behalf of the buyer. Their authority is restricted to a specific task, like finding a property or a buyer, not broad contractual power. They're like a highly skilled assistant hired for a single, specific mission.
Got it. Limited scope, no binding power for the client.
Precisely. Next is general agency. This grants a broader scope of authority to the agent, typical of the relationship between a broker and their sponsored associate licensees, salespersons or broker associates. A sponsored sales agent does have the ability to sign and bind their broker to certain agreements. For instance, a listing agreement.
So the salesperson can bind the broker.
Correct. Because the sales agent operates under the broker's license and can manage all of a principal's affairs within a certain specified area in this case, representing the broker's interests in various transactions. This relationship allows the associate licensee to act on behalf of the broker within the scope of their employment, which often includes signing contracts on behalf of the brokerage itself as long as it falls within their specified duties, like procuring agreements with clients. So while a sales agent typically can't bind a seller to a purchase contract, they can bind their broker to a listing agreement. Okay, that's a key distinction. Binding the broker, not necessarily the end client.
Right. Finally, there's universal agency. This is the broadest type, giving agents the power to act and make decisions on behalf of the principal in virtually all business matters of concern. This level of authority is usually granted via a comprehensive power of attorney, which essentially makes the agent their principal's legal alter ego. It's very rare in typical real estate transactions precisely because it's such an expansive grant of power.
Makes sense. That sounds like a lot of power. It is. However, it absolutely does come with the authority to bind the principal to any number of agreements or decisions. For instance, a universal agent could legally sign a deed to sell a property or enter into a complex lease agreement, all on behalf of the principal. So, to answer your specific practice test question, the two types of agency that come with the authority to bind the principal are general agency and universal agency.
General and universal, got it.
The key takeaway is understanding the specific graduated limitations and powers associated with each type as they determine the extent of an agent's legal reach and responsibility.
Okay, that clarifies the binding authority beautifully. It's not just about being an agent, it's about the type of agent. And speaking of different agents working together, our listener also had a question about who actually dictates what role a cooperating agent plays in a sale. Is it the listing agent, the buyer's agent, or someone else entirely?
That's a really sharp question because it gets to the heart of how different brokerages interact in a transaction and how compensation flows. When an unaffiliated cooperating broker, meaning a broker from another brokerage, and does their associate licensees help a listing broker find a buyer, they can operate in different capacities. What's often misunderstood, and what's fascinating here, is that it's not the brokers themselves who unilaterally decide these roles.
Oh, interesting. So who does decide?
It's important to remember that the seller has the final say on what roles a cooperating agent can play in a cooperative sale. The seller is the ultimate principal in the listing agreement, right? So they maintain ultimate control over how their property is marketed and how other agents may be involved. The seller, through their listing agreement, essentially gives permission and sets the terms for how cooperating agents can participate. They get to choose whether to allow cooperative agents to serve as, well, a couple of different roles.
Okay, so the seller calls the shots on cooperation. What are the options?
One traditional option, though it's increasingly rare in California, is for the cooperating agent to act as a subagent. A subagent is essentially an agent of an agent. In this scenario, the cooperating agent owes the same fiduciary duties to the seller, the principal, as the primary listing agent does.
So even if they brought the buyer, they're technically working for the seller.
Exactly. While legally permissible in California, this arrangement is quite rare today because it can create confusion or potential conflicts if the buyer believes they're being exclusively represented by their agent, when in fact that agent's duties are technically owed to the seller.
Yeah, that sounds potentially messy.
It can be. The most common scenario today, by far, is for the cooperating agent to act as a buyer's agent. In this role, the cooperating agent represents the buyer's interests exclusively. Even though they are working to secure a sale for the seller's property, their fiduciary duties, loyalty, confidentiality, full disclosure are owed solely to the buyer.
Right, that seems much clearer. Buyer's agent works for the buyer.
Precisely. In this situation, the buyer's agent typically receives compensation as a commission split from the listing agent's commission, as agreed upon by the seller in the listing agreement, and offered via the multiple listing service, or MLS. The seller essentially agrees to pay a portion of their total commission to the buyer's agent as an incentive to bring a qualified buyer to the transaction.
So the seller agrees to pay the buyer's agent, even though that agent represents the buyer.
Yes, that's the standard practice. The seller sets the terms of cooperation and compensation in the listing agreement. While the source material didn't explicitly detail brokers' agents as a distinct role in the same way, the overarching point remains. The seller's decision dictates how cooperation occurs. They define the terms in the listing agreement and the MLS offer of compensation. This ensures the seller's ultimate control over how their property is marketed and which agency relationships are permissible in its sale, ultimately protecting their primary interests throughout the transaction. It's always the seller's prerogative to set the rules of engagement for other agents.
Seller's choice. Got it. That clears up the cooperating agent role nicely. Hashtag tag tag shag to go. Demystifying property ownership and title. Let's shift our focus now from the people involved in a transaction to the property itself specifically, how it's owned, and what happens when that ownership changes, particularly under unique circumstances. Your practice test had a question about what happens when someone dies without a will dying intestate. I think many people might just assume the property just reverts to the state, like an automatic sweep, but it's not always the case, is it?
You've hit on a really common misconception, and it's absolutely vital for you to understand the distinction for your exam. If someone dies intestate, meaning without a valid will or any other legal document dictating how their assets should be distributed, their property does not automatically escheat to the state. That scenario, property reverting to the state, is a very specific and, frankly, relatively rare outcome.
Okay, so what does happen then, typically?
Instead, what typically happens is that the deceased person's property will be distributed among their legal heirs according to the state's laws of descent and distribution. Every state, including California, has these detailed laws, which establish a clear, predefined process for how an estate is passed to surviving family members or designated heirs in the absence of a will. These laws prioritize close relatives in a specific order, typically surviving spouses, then children, then parents, siblings, and so on down the line.
So there's a legal pecking order for inheritance.
Exactly. So, for example, if a husband and father in California dies intestate, his property will generally go to his wife and children as dictated by California statutes, not directly to the state. This process is overseen by a probate court, which validates the heirs and oversees the distribution according to law.
Okay, so intestacy means heirs by law, not the state by default. What about F-sheet then? When does that happen?
Right. Escheat is indeed a legal doctrine where property passes to the state, but it only occurs under very limited and specific circumstances. This happens only if the individual dies without a will and without a surviving spouse, lineal descendants like children or grandchildren, or any other known and identifiable legal heirs. It's truly a last resort measure for the state to claim property when there is absolutely no one else legally entitled to inherit it after a thorough search for heirs has been conducted.
So only if they literally can't find any relatives or heirs.
Correct. It's the absolute end of the line. So, for your understanding, the key is knowing that intestate primarily points to property passing to established heirs via state law, while escheat is a much more specific and final scenario of a complete and total lack of heirs, where the property defaults to government ownership.
That's a significant clarification. It really underscores the importance of having a will, but also understanding the state's safety net. And on the topic of shared ownership, our listener had a question about co-ownership types where unequal portions are allowed. What's the key difference between those, especially when it comes to what happens when one owner passes away?
This delves into the foundational unities of co-ownership, which dictate how property is held when there's more than one owner. Understanding these unities is key to differentiating the various forms of shared ownership, especially when it comes to the crucial aspects of unequal portions and, as you noted, what happens upon an owner's death.
Yeah.
This is often where people get tripped up on the exam.
Right, the unities. Let's break them down.
Okay. The form of co-ownership that does allow for unequal portions is tenancy in common. This is its defining characteristic, and is why it's a popular choice for unrelated parties, say business partners. Imagine a group of friends buying an investment property together, where one person puts in 70% of the down payment, another puts in 20%, and a third puts in 10%. They can hold the property as tenants in common, reflecting their different investment levels.
So the ownership percentage can vary.
Exactly. The defining feature here is undivided interest, which means all owners have equal rights to use and possess the entire property, regardless of their specific ownership share. Even if you own only 10%, you have the right to access and use all of it. Crucially, tenancy in common includes rights of inheritance, not survivorship.
Okay, inheritance, not survivorship. What does that mean practically?
It means if a tenant in common dies, their interest passes to their heirs according to their will or the state's laws of descent and distribution. The deceased owner's interest does not automatically pass to the other co-owners. This form of ownership is the most flexible in terms of ownership shares and only requires one unity, the unity of possession, meaning all co-owners have the right to possess and use the entire property.
Got it. Tenancy in common ensures unequal shares. Okay, passes to heirs. What's the alternative?
In stark contrast, joint tenancy is far more restrictive and requires all four unities to exist simultaneously at the time the ownership is created. If any of these unities are broken after creation, the joint tenancy is severed and typically converts into a tenancy in common. These four unities are: 1. Unity possession, just like in tenancy in common, equal rights to possess and use the whole property. 2. Unity of interest, this is the big difference. All co-owners must hold equal shares in the property. If there are 4 joint tenants, each must own exactly 25%. You cannot have unequal portions in a joint tenancy.
Okay, so equal shares are required for joint tenancy, no 70-30 splits.
Correct. If you have unequal shares, it defaults to tenancy in common. 3. Unity of time. All co-owners must acquire their interest at the same time. You can't easily add someone later. 4. Unity of title. All co-owners must acquire their interests via the same instrument, like the same single deed.
Okay, possession, interest, equal, time, title. The 4 unities.
Right. And the hallmark of joint tenancy, its most distinguishing feature, is the right of survivorship. This is the big one. If one joint tenant dies, their interest automatically and immediately passes to the surviving joint tenant, bypassing probate and heirs.
Whoa, okay, so it doesn't go to their heirs. It goes to the other owners automatically.
Automatically. This means the property doesn't go through the deceased's will or intestacy laws. It simply transfers to the remaining co-owners. This can be a desirable feature for estate planning, as it simplifies the transfer of property upon death and avoids the often lengthy and costly probate process.
I can see why people might choose that.
Yes, though it's worth noting the California context regarding married couples. In California, for married couples and registered domestic partners, joint tenancy isn't typically the default. Instead, the law of community property generally applies to assets acquired during marriage. Under community property, each spouse owns a 1/2 equal undivided interest in that property, with some exceptions for separate property, like gifts or inheritances received individually.
So community property is the norm for married couples in California.
Generally, yes. While joint tenancy can be used by married couples in California, community property is the more prevalent legal framework, designed to ensure a more equitable division upon divorce or death within a marital context. And under community property, upon death, the deceased spouse's half can often be willed to someone other than the surviving spouse, unlike the automatic survivorship of joint tenancy. It's a key difference.
That clarity on tenancy in common versus joint tenancy, and particularly the right of survivorship versus rights of inheritance, is golden. It's fascinating how a small detail in how you hold title can completely change the fate of an asset. And speaking of married couples in California, what about this concept of quasi-community property? It sounds a bit unique, like something specifically designed for California's legal landscape.
It is indeed unique, and it's a concept specific to states like California that operate under community property laws. It's designed to ensure fairness for couples who move into a community property state from a common law state.
Okay, so it's 4 people moving to California.
Exactly. To understand quasi-community property, let's first quickly remind ourselves about standard community property. In California, community property refers to property acquired by a married couple during their marriage. This is the default assumption for nearly all assets accumulated while married, and each spouse owns an equal, undivided half interest.
Right, 50-50 ownership for assets gained during marriage.
Correct, with exceptions for separate property like gifts or inheritances. The core principle is that both spouses contribute equally to the marital estate, so it should be divided equally. Now, quasi-community property addresses a very specific scenario. It applies to married couples who move to California from a non-community property state, essentially, a common law state. It refers to property acquired by either spouse that would have been community property had they been domiciled in California at the time of its acquisition.
Huh. So California law looks back at property bought elsewhere.
In essence, yes. California law looks back at property acquired in a common law state, where ownership is often determined by whose name is on the title or who earned the income, and effectively reclassifies it for certain purposes once a couple becomes California residents, particularly in the event of divorce or death.
Can you give an example? That sounds a little complex.
Sure. Here's a classic example, very similar to one you might have seen. Imagine Paul and Raul, a married couple living in Massachusetts, which is a common law property state. While living there, they buy a house, and let's say only Paul's name is on the deed because he was the sole earner who purchased it. Under Massachusetts law, it would likely be Paul's separate property. Later, They decide to move to California and establish residency. If they then decide to divorce in California, that Massachusetts house, even though it was acquired in a common law state and only in Paul's name,
It gets treated differently in California.
yes, it would be treated as quasi-community property in California's divorce proceedings. This means it would likely be divided equally between Paul and Roll, even though it wasn't considered community property when it was originally acquired in Massachusetts. The court applies California's principles to assets that effectively would have been community property had they been in California all along.
Wow. Okay, so it levels the playing field for couples moving in.
It's exactly. The significance of quasi-community property is profound. It's California's way of preventing one spouse from claiming sole ownership of assets acquired in a common law state simply because of how title was held or who earned the income there. Instead, it ensures an equitable division under California's community property principles, particularly upon events like divorce or the death of one spouse. It's a critical mechanism to apply California's philosophy of marital property rights fairly, even when couples have moved from jurisdictions with different legal frameworks.
Let's shift gears now to the financial side of real estate, particularly lending, investment, and those ever-present closing costs and calculations. Your practice test had a question about the difference between equity REITs and mortgage REITs, which can sound like two sides of the same coin, but they're fundamentally different, aren't they? What's the scoop there for someone looking to understand real estate investments?
You're absolutely right. They are quite distinct, and understanding this difference is key for anyone looking at real estate investment vehicles. This involves understanding different ways to invest in income-producing real estate through specialized entities known as trusts. REITs, or real estate investment trusts, are companies that own, operate, or finance income-producing real estate. They're basically designed to allow individual investors to buy shares in large-scale commercial real estate portfolios, much like buying stock in a company.
So, like mutual funds, but for big real estate projects.
Kind of, yeah. They allow you to invest in real estate without directly owning or managing the properties yourself. Plus, they're often publicly traded, offering liquidity. The core distinction between the two main types lies in what these REITs primarily invest in. Equity REITs are the most common type. They primarily invest in and directly own physical properties. Their income comes mainly from rent collected on their vast portfolios of real estate. Think apartment complexes, shopping centers, office buildings, warehouses, hotels, data centers.
But they're like giant landlords.
Exactly. When you invest in an equity REIT, you're essentially buying a slice of ownership in a portfolio of income-generating real estate assets. Their performance is tied to property values and rental income. On the other hand, mortgage REITs, often called M-REITs, take a fundamentally different approach. Instead of owning physical property, they invest in mortgages and mortgage-backed securities, MBS.
So they invest in the debt, not the actual buildings.
Precisely. Their income is generated primarily from the interest earned on their mortgage investments. They essentially borrow money at short-term rates and lend it out via mortgages at long-term rates, profiting from the interest rate spread. So they don't own the physical buildings. Rather, they own the debt secured by those properties. Their profitability is highly sensitive to interest rate fluctuations and the credit market.
Got it. Equity REITs own properties. Mortgage REITs own mortgages debt.
That's the core difference. Equity REITs are the landlords. Mortgage REITs are the lenders.
Clear as day. That makes perfect sense. Now, for one of those ever-present challenges on any real estate exam, and one you specifically flagged, proration calculations. You struggled with a property tax proration and a PITI calculation. Let's break those down step by step. I know these can feel like a maze of numbers, especially in an audio format, so let's slow it down and tackle it together.
The math. You're right. This is where precision is key, and understanding the payment periods is where many people get tripped up. Proration is fundamentally the act of dividing or allocating ongoing expenses like property taxes, utility bills, HOA fees between buyers and sellers based on the actual period of usage or ownership. The goal is absolute fairness at closing, ensuring each party pays only for what they've consumed or for the period they've owned the property.
Makes sense. Splitting the bills fairly based on move-in, move-out date, essentially.
Yeah, exactly. Let's tackle the property tax proration first, using the example from your practice test. An annual tax of $11,160, with closing on April 4th, the buyer owning the closing day, and using a 360-day calendar for calculation convenience.
Okay, $11,160 annual tax, closing April 4th, buyer owns closing day, 360-day year. Let's go.
First, understand the California context. Property taxes here are typically paid over a fiscal year, July 1st to June 30th, usually in 2 installments. The core principle for proration is that the seller pays for the portion of the year they own the property, and the buyer often gets a credit at closing for the seller's share, because the buyer will pay the whole bill later.
Okay, so the buyer pays the bill eventually, but gets reimbursed for the time the seller lived there.
Correct. So step 2, calculate the daily and monthly rates using that 360-day calendar specified in the problem. Annual tax is $11,160, daily rate. $11,160 divided by 360 days equals $31 per day. Monthly rate, $11,160 divided by 12 months equals $930 per month.
Okay, $31 a day, $930 a month. Got it.
Step 3, determine the seller's responsibility period, which the buyer will get credit for. The problem states buyer owns closing day, which is April 4th. This means the seller is responsible for the taxes up to and including April 3rd. So the seller owned the property for January, February, March. That's 3 full months. And the first 3 days of April, April 1st, 2nd, 3rd, that's 3 days.
3 full months and 3 days for the seller.
Right. Step 4, calculate the seller's portion, which becomes the buyer's credit. Multiply the seller's full months by the monthly rate. 3 months times $930 per month equals $2,790. Multiply the seller's days by the daily rate. 3 days times $31 per day equals $93. Now add those together. $2,793 plus $93 equals $2,883.
$2,883. So that's the amount credited to the buyer on the closing statement.
Exactly, because the buyer will be responsible for paying the full tax bill when it comes due for the entire tax period, and this credit accounts for the portion the seller owed for their period of ownership. It balances the books for the tax year closing.
Okay, that breakdown for property tax proration makes so much more sense when you walk through it like that, step by step, explaining why we're calculating the seller's portion as a buyer's credit. The buyer owns closing day detail is crucial there. Let's move to the PITI calculation. PITI sounds like an acronym, so let's start there. What exactly is it, and how do we calculate it?
Excellent point. PITI stands for Principal, Interest, Taxes, and Insurance. It represents the total monthly housing cost for a borrower, excluding maybe other things like HOA fees or utilities. It's the core number lenders look at when qualifying someone for a loan.
PITI, Principal, Interest, Taxes, Insurance. Got it.
Okay, the scenario from your test. $210,000 home, 80% loan-to-value LTV, conventional loan for 30 years at 5% interest, a mortgage factor of 5.37, and annual taxes and insurance of $1,200.
Okay, let's crunch those numbers.
Step 1, calculate the loan amount. The LTV indicates the percentage financed. Loan amount, home price LTV percentage equals $210,000.80. So the loan is for $168K.
Right, 80% of $210K.
Step 2, calculate monthly principal and interest, P&I, using the mortgage factor. The mortgage factor is the monthly P&I payment per $1,000 of the loan amount for that specific rate and term. First, figure out how many thousands are in the loan. $168,000 divided by $1,000 divided by $1,060. Now, multiply that by the given mortgage factor. Monthly P&I equals $168 cents, $5.37, 916 cents.
Okay, $902.16 for the P&I part.
Step 3, calculate monthly taxes and insurance, TI. These are typically paid into an escrow account monthly. Annual TI is given as $1,200 monthly TI. $1,200 divided by 12 months equals $100.
Simple enough, $100 a month for taxes and insurance.
Step 4, calculate total monthly PII. Simply add your calculated monthly PI to your calculated monthly TI. $902.16 plus $100.16.
$1,002.16. That's the total PITI payment.
That's it. And why this matters. This composite calculation reflects the true core monthly housing cost for a borrower, essential for determining affordability and loan qualification. It's the full picture, not just the loan repayment part.
That's a clear, methodical breakdown. I can practically see the numbers on a whiteboard now.
And speaking of calculations and closing costs, your notes also mention confusion around what's not typically prorated at closing. Can you elaborate on that and maybe provide an example or two of items that would almost never be prorated?
Absolutely. This is another area that can cause confusion. Remember, prorated items are ongoing, recurring expenses split between buyer and seller based on their period of ownership or usage, things paid over time.
Like taxes, utilities, HOA fees.
Exactly. Those are commonly prorated. They continue regardless of ownership transfer and need allocation to the closing date. In contrast, certain one-time fees paid at closing are generally not prorated. Why? Because they're associated with the transaction itself or the loan acquisition, not an ongoing service period that needs to be split. They're typically assigned solely to either the buyer or seller based on the purchase agreement.
Okay, so what are some examples of these non-prorated one-time fees? Good question. Let's look at a few common ones. 1, appraisal fees. This is a classic example. Appraisal fees are almost always paid entirely by the buyer.
Why the buyer?
because the appraisal is typically a requirement from their lender to assess the property's value for the loan. It ensures the collateral is sufficient. It's a one-time service tied directly to the buyer's loan application, not an ongoing property expense.
Makes sense. It's for the buyer's loan.
2. Loan origination fees discount points. These are fees charged by the lender for processing the loan or to buy down the interest rate. They're purely a cost of obtaining the mortgage and are paid by the borrower, the buyer, not prorated with the seller.
Also tied directly to the buyer's financing.
Exactly. 3. Inspection fees. Think about the general home inspection fee or a roof inspection fee. These are typically paid by the buyer up front, directly to the inspector. They're a one-time cost for a specific service that benefits the buyer's due diligence, not an ongoing expense that needs to be split.
Right. Buyer pays for their own inspections.
4. Attorney fees. If a buyer or seller hires their own attorney for representation, that legal fee is paid by the party who incurred it and is not prorated. The key takeaway here is distinguishing between costs that are ongoing and period-based versus one-time transactional fees. Understanding this helps both buyers and sellers anticipate their financial obligations at closing.
That breaks down the numbers and the fees beautifully. It really helps to think of it as ongoing service versus one-time transaction cost. Now let's look at who pays what at closing in broader strokes. It's not always intuitive, especially regarding commissions versus other fees. What are the typical expectations for sellers and buyers when it comes to closing costs in California?
This is a point of frequent confusion, but it's where understanding the flow of funds and contractual obligations comes into play. While specific allocations can always be negotiated and will ultimately be dictated by the escrow instructions and the purchase agreement, there are generally accepted typical practices in California that are important to know.
Okay, what does the seller usually cover?
Let's start with the seller's typical expenses. The most significant cost for the seller is almost universally the real estate agent's commission. The listing agreement stipulates this commission, often a percentage of the sales price. This commission then typically splits with the buyer's agent as cooperative compensation. This is almost always the largest closing cost for a seller.
Right, the commission is usually the big one for the seller.
Definitely. Additionally, the seller is responsible for satisfying any existing loan payoffs, paying off their current mortgage liens or other debts secured by the property before transferring clear title. In California, sellers also typically pay the documentary transfer tax, which is a one-time tax, usually due to $0.55 per $500 of the purchase price in most areas, paid upon transfer of ownership.
Okay, commission, loan payoff, transfer tax. Anything else common for sellers?
Other potential seller costs can include the owner's title insurance policy. This can be negotiable, but often paid by seller in Southern California, a portion of escrow fees, which are typically split 50-50, pest inspection reports, and maybe related repair costs, and sometimes a home warranty plan for the buyer.
Got it. Now, what about the buyer side of the ledger?
Moving to the buyer's typical expenses, these are often related to obtaining financing and ensuring the property is acceptable. The appraisal fee, as we discussed, is almost always paid by the buyer. The buyer will also typically pay loan origination fees and any discount points they choose to pay to reduce their interest rate. The lender's title insurance policy is another common buyer cost. This policy protects the lender's investment against title defects and is distinct from the owner's title policy that might protect the buyer's equity.
Okay, appraisal, loan fees, lender's title policy. What else?
Other potential buyer costs can include various inspection fees, home inspection, roof, chimney, etc. Recording fees to officially record the new deed and mortgage with the county. Their portion of escrow fees, again, typically split, and potentially a survey if required or desired.
So buyer's costs are often linked to the loan and due diligence.
Largely, yes. The key takeaway here is that while the final escrow instructions and purchase agreement detail everything, these general practices provide a clear roadmap for the major cost responsibilities. Knowing these helps everyone anticipate their financial obligations.
That's incredibly helpful for anticipating closing costs. And speaking of loans, our listener also needed a refresher on how the principal portion of an amortized loan payment changes over time. It's a constant payment, but what's happening behind the scenes with that principal and interest?
This highlights the fascinating and often misunderstood beauty of amortization. A fully amortized loan, like most home mortgages, is structured so you make equal monthly payments over the entire loan term, say 30 years. However, what's absolutely crucial to understand is that while that total monthly payment amount stays the same, the internal breakdown between principal and interest changes significantly over time. Think of it like a seesaw.
Okay, equal payments, but the inside shifts. How?
In the early years of a loan, the lion's share of each monthly payment goes towards interest. Why? Because interest is calculated on the outstanding principal balance. At the very beginning, that balance is highest. So using your practice test example, a $300,000 loan at 5% interest. The annual interest is $15,000, $300K, or $1,250 per month, $15K, 12. If your total monthly P&I payment is $1,800, then in the first month, $1,250 goes straight to interest, leaving only $550 to reduce the principal.
Wow, only $550 goes to the actual loan balance at first.
Exactly. This minimal principal reduction early on means the balance decreases very slowly at first. You're mostly paying for the privilege of borrowing. But as payments continue, and even that small amount of principal gets paid down, the outstanding principal balance gradually decreases. This is where the magic happens.
Okay, what's the magic?
Since interest is always calculated on this decreasing outstanding principal balance, the amount of interest due each month also steadily decreases. Consequently, to keep that total monthly payment fixed at $1,800, a greater and greater portion of the monthly payment is then applied to the principal.
Ah, so as interest goes down, principal goes up, but the total stays the same.
Precisely. By the middle and later years of the loan, you're paying significantly less in interest each month, and more of your payment is directly chipping away at the loan amount. You start building equity much faster later on.
Let's quickly recap that calculation example.
Sure. For that $300,000 loan at 5% with an $1,800 monthly payment. 1. Calculate first month's interest. Annual interest equals $300,000.05 equals $15,000. Monthly interest equals $15,000. 12 equals $1,250. Calculate first month's principal payment. Total monthly payment. Monthly interest equals $1,800. $1,250 equals $550. And the trend continues. For the second month, the principal is slightly lower, $299,450, so the interest is slightly less, and the principal payment is slightly more. This accelerates over time.
That's a fantastic explanation of amortization, really demystifying how those payments work over time. Hashtag IV, clarifying legal documents and best practices. Now let's transition to legal documents and best practices, another area where a single word can change everything. Your practice test had a question about the best evidence of title. What's the definitive answer there, and why is it considered the gold standard?
That's a crucial question, because how ownership is proven and secured is fundamental to any real estate transaction. While several documents and concepts provide evidence of title, one stands out as offering the most comprehensive protection for the owner in most modern real estate transactions. It's often considered the gold standard.
Okay, what are the contenders for evidence of title?
Well, you might encounter an opinion of title, which is a lawyer's professional assessment based on reviewing public records. It's an opinion, not a guarantee. Similarly, a certificate of title is a formal statement from a title examiner or attorney affirming the title appears clear based on a public record search. It confirms what the records show. Then there's the Torrens certificate, part of the Torrens system used in some places, not super common everywhere. It's a government-issued and guaranteed statement of title considered conclusive.
Okay, opinion certificate, Torrens. What's usually considered best?
In most U.S. states today, including California for the most part, title insurance is generally accepted as the best evidence of title. It's not just a statement about the title's current state. It's an actual insurance policy that provides crucial financial protection.
So it's insurance, not just a report. How does that make it best?
Title insurance indemnifies or financially compensates the insured party, the buyer, with an owner's policy, and their lender, with a lender's policy, against financial loss if defects in the title are discovered after closing. This protection extends to defects that might not have been found during a diligent title search or issues that existed before the search. Things like undisclosed errors, forged documents, errors in public records, misfiled documents.
Ah, so it covers hidden stuff or mistakes that a search might miss.
Exactly. Unlike an opinion or certificate, which just report findings and offer no financial recourse if something was missed, title insurance actively indemnifies against losses from covered defects. It offers a financial safety net and even legal defense if someone later makes a successful claim against your ownership. This robust protection against unforeseen or hidden issues makes it the strongest assurance, providing peace of mind.
That makes perfect sense. Insurance offers protection beyond just a statement or an opinion. It's a true safeguard. Another point of confusion from your practice questions was around involuntary liens. Can you clarify what they are and provide an example that makes it clear how they're different from, say, a mortgage?
Absolutely. Liens are financial claims against a property, acting as security for a debt. The key distinction is whether these claims are voluntary or involuntary.
Okay, voluntary versus involuntary. What's voluntary?
Voluntary liens are created when a property owner willingly uses their property as collateral. The most common example is a mortgage. When you get a home loan, you voluntarily agree to place that lien on your property in favor of the lender. It's a consensual arrangement you chose.
Got it. Mortgage, voluntary. So what's involuntary?
Involuntary liens are financial claims placed against property without the owner's direct consent. They usually arise by operation of law, typically due to unpaid debts or legal judgments. The owner doesn't choose these, they're imposed.
Okay, imposed liens. What are some examples? Your test mentioned one.
Right. Let's look at a few common involuntary liens. 1. Property tax liens. This is critical. If you don't pay your property taxes, the local government automatically places a specific involuntary lien against that property. These liens have the highest priority over almost all others.
So unpaid property taxes lead to an automatic high-priority lien.
Correct. 2. Mechanics liens. This is another classic example. If a contractor or supplier does work or provides materials for improvements, like a roof repair in your example, and isn't paid, they can file a mechanics lien against the property to secure payment. While the owner consented to the work, they didn't explicitly consent to the lien. The lien is imposed as a legal remedy for non-payment.
Ah, so the lien itself is the involuntary part, even if the work was requested.
Precisely. 3. Judgment liens. These arise from a court judgment where someone owes money. If a creditor sues you for unpaid debt and wins, the court can order your property subject to a lien to secure that debt. Again, while the underlying debt might have been voluntary, like a credit card, the lien itself is involuntary once the court imposes it. The key distinction is the origin. Owner's choice, voluntary versus legal imposition, due to outstanding debt, involuntary.
That makes the distinction crystal clear. It's about consent, or lack thereof. And finally, let's talk about one of the biggest ethical and legal pitfalls in real estate. Dual agency, specifically undisclosed dual agency. What exactly is it, and why is it such a big no-no, both legally and ethically? It feels like it should be obvious, but it can still be confusing.
You're absolutely right. This is a critical ethical and legal issue, and it's something every licensee must understand thoroughly as it came up directly in your practice test. It hits the foundation of trust.
So first, what is dual agency generally?
Okay, dual agency occurs when both the buyer and the seller in a single transaction are represented by the same brokerage. This doesn't necessarily mean the same individual agent represents both. It means the brokerage itself has a fiduciary duty to both parties in the same deal.
Right, the brokerage represents both sides. Is that even legal?
Well, disclosed dual agency is legal in California, but it comes with very strict requirements. It mandates informed consent from both the buyer and the seller. The broker must clearly explain the implications, like they can't advise one party over the other on price or terms before everyone agrees. They become neutral facilitators on those points. Forms like AD and AC ensure this disclosure and consent. Transparency is key.
Okay, so disclosed and agreed upon, it's okay, but limited. What's the problem then?
The problem, and the big no-no, arises with undisclosed dual agency. This is the specific term for when both parties are unknowingly represented by the same broker. Neither the buyer nor the seller is aware that their interests are supposedly represented by the same brokerage, or maybe even the same agent.
Ah, so it's happening behind their backs. Why is that so bad?
Why is it illegal and profoundly unethical? It's a serious violation because it inherently creates an insurmountable conflict of interest. A broker simply cannot fulfill their fiduciary duties, loyalty, confidentiality, full disclosure to both parties simultaneously without one or both being aware of the compromised position. For example, if a broker knows the seller's lowest acceptable price and the buyer's highest offer, how can they ethically advise both to get the best deal? That knowledge inherently favors one party, betraying the duty of loyalty. It breaches fundamental trust.
Yeah, you can't serve two masters equally in that situation, especially if they don't know about each other.
It's exactly. The consequences of undisclosed dual agency are severe. It's a serious violation of agency law and can lead to significant disciplinary action from the California Department of Real Estate, DRE, including license suspension or even revocation. Beyond regulatory penalties, the wronged parties can also sue, leading to potential lawsuits, loss of commission, and substantial financial damages. The bottom line is that transparency and informed consent are paramount. Any deviation, especially undisclosed dual agency, carries huge risks.
Wow, okay. Undisclosed dual agency, definitely avoid that. Huge legal and ethical minefield. We've really peeled back the layers on some of the trickiest concepts in California real estate, from the nuances of agency termination and agent powers to cracking those proration calculations and understanding critical ethics like dual agency. You've just gotten a deep dive into some key areas that can truly make all the difference on your exam, turning confusion into confidence.
Our goal was absolutely to take those specific points of confusion that you identified and transform them into pillars of understanding. Remember, true mastery comes not just from knowing the answer, but from really understanding the underlying principles and their practical implications, especially in real-world scenarios. This raises an important question for you, maybe. How will you integrate this deeper understanding into your ongoing study routine? How can you practice applying these concepts until they become second nature?
Exactly. Take this knowledge, maybe go back to those specific practice questions and see how much clearer they feel now. Perhaps even try explaining these concepts out loud. Sometimes teaching it is the best way to learn it. You've absolutely got this. And we're always here to help you dive even deeper next time. Until then, keep learning, keep asking those insightful questions, and keep building that well-informed foundation.